Do you remember the last time Obamacare came before the Supreme Court? It was kind of a hot mess.
So it appears as if the Supreme Court justices have struck down the individual mandate, the centerpiece of the health care legislation.
We have breaking news here on the Fox News channel. The individual mandate has been ruled unconstitutional.
We're getting conflicting information. We're getting conflicting information. The question is, has the individual mandate been upheld or has it not? And it appears that the answer is the law will stand.
Repeal it now! Repeal it now! Repeal it now!
Well, today, the Affordable Care Act was back before the court for a rematch of sorts as part of the right's indefatigable quest to subvert, destroy, or at the very least whittle away at the edges of the law. The question this time, and the reason there were hundreds of activists outside the Supreme Court today, was whether a corporation can object to mandatory birth control coverage in health care plans based on that corporation's claim of religious liberty. Most of today's protesters were there to argue that no, the owner of a giant company should not be allowed to restrict his employees' health coverage based on his own personal religious beliefs. The lead plaintiff in the case, Hobby Lobby, had its supporters outside the courthouse as well. The chain of 500 arts and crafts stores with 13,000 employees is owned by CEO David Green, who objects to certain methods of birth control like IUDs. Bear in mind, the preventative care coverage mandated under the Affordable Care Act includes literally dozens of screenings, services, drugs, and immunizations, most of which have nothing to do with contraception. But so far, the only one that's being challenged, all the way up to the Supreme Court on religious liberty grounds, involves women's ability to control their own reproductive health, something several women justices couldn't help but note. Joining me now, Dahlia Lipwick. She's senior editor at Slate.com, where she covers the Supreme Court. Dahlia, there is so much to get to in this argument, but before we do any of it, I just want to make this one point, which is that the factual claim Hobby Lobby is making, which is that certain forms of contraception they object to are actually abortion, is an untrue factual claim about the actual science, right? I just want to establish that because everything proceeds from there.
You can establish it for your purposes and for the purposes of life, Chris.
Which is important.
Which is important, but I just want to be clear. Not only does that almost not matter, it almost doesn't arise today.
Right.
But the Solicitor General's office goes further and says, you know what, we are just going to assume that they are in good faith when they say that this is what they believe, and we're not touching it. So over and over again today, the issue, you're watching it not come up, the issue of, you know, you say this is an abortifacient, science disputes that, all of popular medical opinion disputes that. It doesn't get heard. And not only that, but the SG's office goes so far as to say, we take your word. If you believe this, we will not probe that question.
So the big thing that I think immediately when people think about this, I think about, there's a few things. So first is, corporations. Are corporations the kind of entities that have religious conscience, religious liberty, as opposed to individuals, human beings? And at some point, Justice Sotomayor talks about that. She says, how does a corporation exercise religion? I mean, I know how it speaks, and we have, according to our jurisprudence, 200 years of corporations speaking in its own interests. But where are the cases that show a corporation exercises religion? Is the court in new ground here?
It's clearly in new ground, and this is one of the issues that comes up, and Donald Verrilli, the Solicitor General, says over and over again what Hobby Lobby and Conestoga, which is the Pennsylvania cabinet maker, the other plaintiff in this case, what they are asking for is totally legally unprecedented. They're asking to have not just a corporation, be clear, a for-profit corporation. They are asking to say that it has free exercise rights, that it is a person for purposes of RFRA, the Religious Freedom Restoration Act, and this has never been done. And you're going to cry when I tell you this, but Justice Scalia's response to, well, no court has ever held that corporations have religious freedom is, well, no court has ever not held that they, so, you know, you can, that's how my 8-year-old argues, but, you know, that's the answer, is that it's never not been done, so there we are.
So after you sort of establish this, so let's assume, let's say a corporation's a person for these purposes. Let's say there's some kind of interest here. Okay, then I think the next thing people hear of this case is, well, what are the slippery slopes? And there seem slippery slopes in either direction. One of them, Sotomayor again brought up today. She says, is your claim limited to sensitive materials like contraceptives, or does it include items like blood transfusions or vaccines? For some religions, products made of pork. Is any claim under your theory that has a religious basis, could an employer preclude the use of those items as well? That seems to be a fairly devastating argument. I mean, what is Hobby Lobby's lawyer's answer to that?
Well, his answer to that is, let's confine ourselves to this sensitive materials. And already, you know, red flags are, why is this sensitive, whereas AIDS treatment, blood transfusions, and, you know, civil rights laws are not sensitive? I think that's code for, has to do with sex. But he tries to cabin it, Chris, by saying, you know, those other things are different. This is about something that isn't that sprawling array of other, you know, parade of horribles. And he goes on to say, look, you know, RFRA's been around since 1993, and we haven't seen Jehovah's Witnesses come forward, and we haven't seen Mennonites come forward, and we haven't seen this parade of horribles, so clearly they're not out there. That's the response.
Judge Anthony Kennedy kind of did the slippery slope on the other side, basically saying, under your view, and this is again to the Solicitor General Don Verrilli, who's representing the federal government in this case, under your view, a profit corporation could be forced, in principle, there are some statutes on the books now which would prevent it, but could be forced in principle to pay for abortions. I have to say, I was not clear that wouldn't, I mean, what does Don Verrilli say to that? Yes, right?
Well, he's in a tough spot.
Or he's smart enough not to say yes.
He doesn't say yes, but he's in a tough spot. But I want to just emphasize that Chief Justice John Roberts, who people thought might be neutral on this, the way he was kind of trying to broker a deal in the ACA cases, Roberts came right out and said, yes, it's clear for their purposes, by their beliefs, this is being forced to provide an abortion. And Paul Clement, in his closing, said exactly the same thing. So that's the impression you're left with, that this is the slippery slope to think about.
So what does this mean for the next line of cases? One of the things, if you take a step back here, that I kind of have this sneaking suspicion, I don't want to impute bad faith, but let me just say that it does feel a little bit like you can't please these folks in this sense, right? So in this case, you've got this for-profit corporation says, we don't want to do this birth control mandate. Coming up before the court, you're going to have the Little Sisters of the Poor who have an accommodation under the law where they have to sign a form so they don't have to provide this birth control coverage. And they're saying signing the form itself violates their religious liberty. It does feel a little bit like people have a problem with the law, or they have a problem with birth control, more than they have these sort of abstract principle beliefs, and maybe I am interpreting them through bad faith.
No, I mean, one of the interesting side skirmishes that didn't get much press today is the court kind of pressing Paul Clement on, look, if they just have to sign the form the way the Little Sisters have to sign the form, would that be enough, or does that trigger abortions in their view?
Right.
And Paul Clement has a tough time answering. So you're quite right to say the next line of defense is going to be, we object to this too, and that worried the liberal members of the court a lot today.